On behalf of the Ministry of Justice and Constitutional Affairs, I extend a warm welcome to you to this, our second virtual Justices of the Peace Sensitization session for the fiscal year 25-26. Please make welcome the Senior Director, Land Administration and Management at the Land Administration and Management Division of the National Land Agency, Mrs. Georgette Stewart Harrison, who will expound on the topic. So please welcome her. Ms. Harrison, please go ahead with your presentation.
Okay, allow me to just share. Are you seeing my screen?
Not as yet, Georgette. We're seeing you and we're hearing you, but we're not seeing your screen as yet.
Okay, just a sec.
Thank you, Father.
Now, are you?
It is coming up. It's loading. Yes, we're now seeing it.
Okay, all right.
Can it be in slideshow?
I will be doing that shortly.
Yes.
So it's in slideshow. Let's see. Okay. Are you all seeing it now?
Yes. Thank you.
Great. Wonderful. All right. Good evening, everyone. So my role this evening is to share with you what we do at the Land Administration Management Division in the National Land Agency, and particularly how what we do will assist you individually and how you can use that information for the benefits of the citizens within your community. So we'll be looking this afternoon on a background to land matters in Jamaica, the Special Provisions Act, which governs what we do at the division, how we do regularization applications, and I'll tell you what that is, what are clarification applications, how does the adjudication services work, and your role in the land applications moving forward. So in Jamaica, there are basically two types of ways to hold land. We have registered and unregistered land, and we have found that those persons who have registered land generally seem to have better benefits and protection than those who don't. We have been concerned, however, that it has been really difficult.
Mrs. Harrison, but
Yes?
we are seeing somebody's telephone screen instead of yours.
Really? Okay.
Okay, thank you very much, A.M. White. I'm going to remind us though, as helpful as we wish to be, please do not unmute your mic. I will try to administer the session with any hiccups. Please do not unmute and engage unless we're at the Q&A section. Thank you.
Is my screen being shown?
No, it is not being shown as yet.
All right, let me just exit. All right, let me go again. All right, just checking if you are seeing.
Not seeing your screen as yet. Would you like to continue while I upload and share?
Sure, thanks.
Okay.
Nothing is coming up. Just not hearing anything.
Please mute your mics. Claudette Nelson, we're hearing you. Nothing is showing on the screen. We're having some technical challenges. So Mrs. Harrison will continue to present, and then we will attempt to share the screen so you can see what is happening.
Let me stop sharing so you can upload.
Right. So just proceed, and as soon as I can quickly upload, I will upload so that they can see the screen.
No problem. Okay, so I was at the point where I was indicating that there are really two ways to hold land in Jamaica. You can either have registered lands or unregistered lands. And those persons who have registered lands tend to have better benefits and protection than those who don't. Over the years, we have been trying to increase the registration of land, but we have had certain barriers, and that is because our main legislation that relates to registering land has some strict requirements. So some of these barriers, for example, are if you are registering a piece of land, you need to show that you have documentation. So for example, if you were to buy a piece of land in 2000, you need to show a sale agreement. Right, we're right there. Thank you very much. We need to show a sale agreement, which basically shows how you came by the land, but you also need to show good root of title. So you now also need to show how the person from whom you bought the land got the land back to at least 30 years. And in addition to that, you need to lodge a diagram, which is pretty expensive. A quarter acre of land costs about $110,000 to survey. And if you are cutting off a small piece of land from a bigger piece of land, it's even more expensive, because then you have to survey the entire property and have your surveyor do an application to the parish council to have subdivision approval. So those are some of the barriers that persons who try to register their lands have faced over time. Now, because of these barriers, next slide, please. In 2005, the registration of titles cadastral map, just back a little for me, please. Yes, thank you. So in 2005, the Registration of Titles, Cadastral Mapping and Tenure Clarification Special Provisions Act was passed. And this act was passed to address the barriers that I just told you about, and to provide for certain approvals, exemptions, and waivers, so that landowners will want to register their land. So these things should have acted as incentives to make the landowners now want to take the step to move to registration. So next slide, please. So the Land Administration Management Division, right? So if you looked on your slides, you would have seen LAMP. Prior to our division coming forward, LAMP was the original unit that was put in place to administer this act. In 2019, LAMP joined with the National Land Agency, and the Land Administration and Management Division was formed. And so our division is responsible for non-systematic ad hoc land registration. And that just basically means that when persons come to us, they have to do it voluntarily. They have to want to have their lands registered. And so these registrations either come to us directly, where persons come to us at 8 Arden Road to have their matters administered by us, or they come through their lawyers, or their applications are submitted through Geoland. All right. Now, next slide, please. So let me tell you a little about this act. So Section 3 allows for our minister to declare an area as a project area. So the minister was the prime minister. Our current minister is Mr. Robert Montague, and the minister has the power to declare an area as a project area. Now, to date, all parishes in Jamaica, save and except for parts of Kingston and St. Andrew, have been declared. So the parts in Kingston and St. Andrew that are declared are Rosetown, Tel Aviv, Southside, Rose Gardens, Lawrence Tavern, Rock Hall, Joppa, Akiwalk, and Jacksontown, Golden Spring, and St. Andrew. And if you go to the next slide, in recent time, we also declared Stanville, also called Standpipe, in 2025, January 25 of this year. So what has happened is, because of financial constraints, we've had to do this in part. So we started with St. Catherine in 2006, and we went to Clarendon and Manchester and St. Elizabeth in 2008. and then to Rosetown and St. Elizabeth and St. Thomas in 2009, and then Portland and St. Anne and St. Mary came on in 2010, Hanover, St. James, Trelawney, and Westmoreland in 2011, Lawrence Tavern, 2016, 85 Reddy's Road in January 2017. We had Nuggerhead and Rock Hall in 2017 and Tel Aviv in 2019. And then we went to Golden Spring and Joppa St. Andrew in 2019. And Portmore, all of Portmore was declared in 2024, Akiwalk and Jacksontown in 2025, and Stanville and also called Standpipe, January 2025 were declared. Next slide. So what does it mean for a property to be declared as a project area? It simply means that once you are in a parish that has been declared, and as I indicated before, that is all parishes, save and except for parts of Kingston and St. Andrew. So it means that almost all of you can benefit under this act. It means that all these exemptions and waivers that you would normally have to come through LAMD to get, you can now get it just by virtue of having your properties within these parishes, right? So let us look at some of these exemptions. Under Section 5, we have an exemption from the Local Improvement Act and the power to impose covenants. So that is where someone has land that forms part of a bigger piece of land, and they are cutting it off. They have cut it off, and so they would need to go to the parish council and get subdivision approval. Now, once subdivision approval is granted by the parish council, they usually give you certain covenants and restrictions that you must abide by. However, we can apply to our minister for a waiver from the subdivision approval, and it will not take into consideration any covenants. It will not give you any binding covenants, nor will it refer to the Land Development and Utilization Act. So the Land Development and Utilization Act usually restricts how land can be used, whether it's agricultural land or commercial land or land for homestead, right? Again, the minister has the right to waive these references. Section 5 also allows for exemption from transfer tax, not for value. So that means if you have a piece of land and you want to add your spouse, or you want to add a child to it, it's not for money, it's not for value, it's not for conservation, it's not a sale. It's called a transfer, not for value. And so under the act, we are allowed to give persons a waiver from transfer tax. So let me give you an example. Transfer tax right now is 2%, right? If you are transferring your land that values $10 million to your child, you would have to pay the government $200,000 of transfer tax. If the application comes through the Land Administration Management Division, which is our division, we will charge you a fee to process the waiver, but it would be based on the tax roll value and not the true value, which is at $10 million. So say the tax roll value is about $3 million, you'll pay roughly about $61,000 to $71,000 for the processing fee, which is way less than the $200,000 that you would have paid if you had gone straight to stamp office. Also, there are exemptions from stamp duties and registration and recording fees. So again, sometimes clients come to us, they have a sale agreement that was done from in the 1960s or in the 1980s, but it was never stamped. And when you're doing the registration application at the titles office, they require that all transaction transfers and sale agreements be stamped. Those matters can be stamped by the Land Administration Division. We have a stamping unit, and we can exempt the stamp duties. So there's no need to go through the tax office or the stamp office. We also allow for exemptions of transfer tax on debt. And again, this is where someone would have died. Once someone dies and you're passing the land from the executor to the beneficiaries, you're required to pay transfer tax because it is a transfer happening. And transfer tax right now is 1.5% of the value of the true value. Again, we charge based on the tax roll value, our fees to process, and it will be way cheaper than you going through the tax office. Next slide, please. So to look at the waiver. So how does this work? So say you have a piece of land, as I indicated, a small piece of land coming out of a bigger piece of land. We have it all the time. You have title and you decide to sell a piece of it. You have a 1 acre piece, you're selling a quarter out of the 1 acre. that person who has bought that quarter acre cannot get a title for him or herself unless she goes through the parish council to get a subdivision waiver. However, if you can show us that the informal subdivision, in other words, you bought the land over 7 years ago, so you have a sale agreement that can show that, or when you were buying it, the vendor had given you a survey or a diagram or a plan, which is over 7 years, that in and of itself would show that the informal subdivision has been in existence for at least 7 years. Then we'd ask you to complete a form, and that form would basically give us information. Where is this land? On the tax roll, how much square meters is it? 2,000 square meters, but you bought 500 square meters from the 2,000 square meters. You will submit your survey diagram. And by the way, a survey diagram is only good for 7 years. So if it's older than 7 years, you will need a surveyor to do a declaration to say that the boundaries have not changed. And that is called a surveyor's declaration. And that must be submitted with the old survey. Otherwise, you're going to have to do the survey over from scratch. And that may take a long time because to process the surveys can be anywhere between 6 months and a year. So a surveyor's declaration might be good, better for you, easier for you, cheaper for you. And it is good for another 7 years. You'll also be required to submit a property tax receipt. Remember, I said to you, we do a calculation based on the advice fee. So we need to know what the tax roll says is the value. And bear in mind that the tax roll's value is always extremely lower than the true value. So if you see $2.5 million on your tax receipt, it means that your property value is $12 million or $15 million, right? In reality. And we ask that you submit a copy of the certificate of title. And then we put that together. We send the request to the minister to ask for the waiver. The waiver is signed, and then you can use that along with your application document at the title's office to get a splinter title. Okay? Next slide, please. Okay, so when do we normally use these Section 5 waivers? So as I indicated before, one where you have a registered piece of land and you already have a title, but you sold a piece of the land or you gave a piece to your child or husband or friend by deed of gift. So a piece has been cut off and this person now needs a title for him or herself. You can get a waiver. So that waiver will be lodged along with your part of land transfer and your title and your plan to the title's office, and the title's office will issue a new title for the new person for their little piece, and the remaining piece will be left back in the title for the original owner. Or where you're making an application for first registration, there's no title, but it's a big piece of land and the person has cut it up and give you, out of their 10 acres, they probably give you a quarter acre. So when the application goes to the referee at title's office, he's going to see on the tax roll that there is 26,000 square meters on the tax roll, but your diagram is only showing 500 square meters. He's going to ask for either that you're giving a subdivision approval or you get a waiver from the minister to say you don't need a subdivision approval. So those are the two instances in which a Section 5 waiver is required. Next slide, please. So Section 6. So we have what we call cadastral maps. They're really just a big joint map of individual lots, right, that are done. And once they are done and treated as cadastral maps, then it means that you don't need an individual diagram because the big map would have captured everything and there would be a cadastral map number for each lot. So that, of course, would help to reduce the cost of titling. Also, Section 7 allows for us to enter into agreements and arrangement with any public sector, private company, or individuals as the minister may deem fit. And so to this end, we have had some agreements, some arrangements. So we have one with Jamaica and Naranda Bauxite right now. So when their matters come in on behalf of the persons who they have sold lands to, and they're now trying to get titles for them, they get a special fee, a reduced fee. We used to have an arrangement with Geoland, but that contract ended last year, September. So Geoland is treated like any regular person, but they would still get the benefits on the Special Provisions Act that I just indicated at Section 5 and Section 6. And so their clients will also get the benefits. And also recently, the minister approved what is called a certification arrangement. So this certification arrangement is where we train attorneys at law. We have our one-day training with them. We basically teach them how to do the various applications to ensure that when their matters are lodged at the titles office, their rejections are low or not at all. Once they are trained by us, they become certified attorneys, and it means therefore that when their clients' matters are referred to us, their clients will also get all the benefits that comes with having the use of the Special Provisions Act. Okay, next slide. Okay, so there have been some recent amendments to the legislation, and one of that amendment is for registration fees to be reduced. So to give you an example, when you apply under the Registration of Titles Act for a first registration, you are required to pay 1% for registration fee and another 0.5% for an insurance fee. When you do the application under the Special Provisions Act, we use the tax rule value. And consequently, as I indicated, the average value for property in Jamaica is $10 million. If you were to apply under the Registration of Titles Act directly, you would have to pay about $150,000 for registration fee. If you apply under the Special Provisions Act, your fee would be about $15,000 when we add all the fees together. So a significant savings for anyone who brings their action under the Special Provisions Act. What happens is that you have the option of either coming directly through us or through your attorneys. The beauty of going through your attorneys is that once we certify the matter, the attorneys don't have to wait on us. They can lodge directly to the title office, and if there are any rejections, they can deal with them very quickly. And so there are some persons who would prefer to go through their attorneys at law. Also, we have what is called a record of decision, and I will tell you a little more about that, but that's a decision that is made by an adjudication committee. Once the committee makes that decision and a certificate is issued, there is no need for it to go through a referee. So under the Registration of Titles Act, our applications are sent to a referee who is an independent body within the titles office. And if you do not meet the requirements, remember the barriers I told you about before, if you don't have the documentation, if you can't go back to 30 years, if you don't have your plans and so on, the referee is going to reject your document. However, with a record of decision, once we have that in place, you just lodge your record of decision and your plan, and it's not sent back to a referee, and title will be issued within a month. So those are some amendments. Next slide. So this just basically shows the percentage of land that are registered in our country at this time. This was done about 2 weeks ago. When I looked on it yesterday, all these figures were up by about 2%. So we are seeing an improvement in the number of lands that are being registered. So for example, when I check St. Anne is now, St. Anne on your screen is 56.27. St. Anne is now 58.9% of lands that are now registered. And Trelawney was 55.5%. It is now 58.63%. So we are very happy about that, because we are in fact seeing an increase in the number of lands that are registered. And we are coming from registration being as low as 20. And that is exactly why we're speaking with you today, because we want you to help us to tell other people about how they can get their lands registered, because we want before 2030 to have everyone, we want all of these figures to go up to 100%. Next slide, please. So next slide. Next. Clarification matters. So clarification matters are those matters where there is already a title in place. So our mandate at the Land Administration Management Division is not only to help those people who don't have title, but we are also mandated to help those persons who have titles to update these titles. So we have found, for example, that there are persons who have a piece of land and they want to add a name, or they want to remove a name, but because the transfer tax is so high, they are usually reluctant, or they just can't afford to. Remember, Section 5 allows us to give a waiver of transfer tax. So those matters we do. Then we have those situations where somebody would have sold a piece of their land for many years, but is unable to issue a title to the person whom they have sold it to because they don't have subdivision approval. They can't afford the 100,000 or the 500,000 to survey the land and then the money to go to parish council to have it subdivided. Because once parish council gives an approval, they give restrictions. They want road, they want light, they want water in place, and so it can be a very, very expensive. So we deal with those matters. Part of land transfers where somebody has died. So you have two persons on a title, but one of the owners died. We do what are called notation of death, where they hold as joint tenants. Now, if someone in the title subsequently got married, we also do notation of marriages where we add the married name. So the woman's name would have changed. So her TRN now has her married name, but untitled, her previous name is there. We have to do a notation to add that new name. Or an application to be registered on transmission. Again, this is where there are more than one person on the title, but they hold as tenants in common, meaning they have distinct shares. So one person may have a quarter share and the other has a 3/4 share. The one with the 3/4 share died. Their estate would have to be administered. Once their estate is administered, then their share would have to be noted on the title. So we do that application to have them registered on transmission and to have the beneficiary's name registered for that person's 3/4 share. And we also do loss or destroy title applications. So those are clarification matters. You already have a title, but there are things on the title that need to be fixed. We assist with that. Next slide, please. Okay, so the documents that you would generally need when you are doing a clarification application, we generally need anything usually that the stamp office would need. So we need names, occupation, address, TRN for all the parties who are involved. We will need the original duplicate certificate of title. We're also going to need the certificate of payment of property taxes, a death certificate if we're doing a notation of death, a marriage certificate if we're doing a notation of marriage, and survey diagram if applicable. So the survey diagram would be if you are taking off a piece from a bigger piece, like a part of land transfer. Next slide. So regularization. So regularization matters are those matters where the lands in question are unregistered. So there are two. One, the land in question is unregistered, or two, there is a certificate of title, but the person who is living on the land, the person who is in possession of the land is not the owner. So next slide, please. So the application that we normally do for these regularization matters are: one, an application to register land, to bring land under the Registration of Titles Act, or we can do an adverse possession application, that is where the person is not the owner of the land, but they have been on the land, they have been living on the land, they have been treating the land as if it belongs to them, and people believe them to be the owner of the land for over 12 years. They can apply to adversely possess the land. Or we do what is called a registration, re-registration by plan. So we have titles, for example, that were done many years ago, but they were done by estimation. What we have found is that because they were done by estimation, these persons sell. So they estimate that they have 10 acres of land, for example, but they are selling. Okay, somebody's mic is open.
Can you mute your mic, please?
Okay, so the land I was explaining to you, a land that was done by estimation, a plan that was done by estimation. So the title may have estimated that they have 10 acres of land, but they have been selling to people over time. So they sell 1 acre, then they sell 2 acres, and they sell 3 acres. But when the registrar checks, when it reaches down to 1 acre, she may realize that there really isn't 1 acre left. because it was done by estimation. So at that point, she may say, we're not going to allow any further part of land transfers until you do a diagram to say exactly how much land is left in the plan. And in that case, you would have to re-register the plan, the title by plan. Okay, next slide. So the documents you usually need for regularization are similar. We usually need to know the names, the occupation, the address, and the terrain for all the parties involved, because the applicant, usually we need to know that about them. We usually ask for 2 supporting declarants. We also need that information. We need their age and their address, so we can determine if they can really speak to 30 years, right? Because if someone is 45 years old, they can't speak to 30 years, because it means that for them to speak to 30 years, they would have been 15, and you have to be an adult. So you'd have to be 18 first, and then you are able to speak about 30 years from that. So the supporting declarants need to be at least 48 years old. So we need their ages to determine that. And the referee will look at that in determining whether or not the person who proposes to support the application can in fact support the application. We're going to need a pre-check plan. It's very important that we're able to identify the boundaries. We don't want dual registration and one piece of land getting 3 and 4 titles. So the pre-check plans assist us with preventing that from happening. A surveyor's declaration if the diagrams are over 7 years, and I'd explain to you that a diagram is only good for 7 years. And so if it's over that, you need a surveyor to do a declaration to say that the boundaries have not changed. An up-to-date certificate of payment of taxes, again, always important, because that's what we use to do your calculation in terms of your fees. Documentary proof of ownership, and that is if you have it. I have found that Jamaicans tend to do a lot of things by word of mouth. So the documents, they buy land, they don't have any sale agreement, the receipts are lost, or they get washed away, or they get lost or faded, or hurricane come and blow you down the house top and everything get wet and soaked. So sometimes documentary proof is difficult. And in the case where we are doing our re-registration, we would need the original duplicate title. Next slide. Next one, please. Okay. So estate matters, as I indicated to you, sometimes you may own land with more than one person, or the person who owns the land may have died. Now, when someone dies, their property doesn't automatically pass to who they say must get it. So if they make a will, then we'd have to apply for a grant of probate. If they did not make a will, then we have to apply what is called the Interstate Estates Property Charges Act, which is an act that says who can benefit. So usually it's the wife or spouse who's in first priority, and then the children. If there are no wife and spouse, then the parents and siblings. If there are no parents and siblings, then half brothers, aunts and uncles. And if there are no aunts and uncles, then cousins. And if there are no cousins, then it goes bona vacantia, which means it goes to the government. And if somebody wants it, they would have to petition the GG for the land. So we do grant of probate, we do grant of letters of administration, and we do grant of letters of administration with will annex. And that is where someone has made a will, but the executors say, listen, I don't want to get involved in this, so they refuse to act. Or the executors have died. In that case, we use the will and we ask that one of the beneficiaries do the application under a grant of administration. Next slide, please. Thank you. Next one. So we have what is called an adjudication services division. It's another division which is also governed by the Special Provisions Act. And what this division does is to consider all claims of interest in a designated project area and prepares records of preliminary findings for public notice. It considers objections to the decisions, and it also acts as a secretariat. So basically what the adjudication services does, it either does systematic registration. So if you're in a systematic area, they send in lawyers, they send in surveyors, they go door to door and they meet with the persons. If someone says, I am the owner, and a sibling or a relative comes and objects, then that matter has to be sent to an adjudication committee for the matter to be heard between the parties to determine who the true owner is. Next slide. So that's one role that they play. Also, I was explaining to you that when the matters are brought on the Registration of Titles Act, there are strict requirements. However, the Special Provisions Act allows for us to bring the matter before an adjudication committee if our clients can show that they have been in possession for over 12 years. So we have a client who comes to us, for example, they have a sale agreement. They bought land from John 12 years ago. They are unable to say who John bought it from. They have no documentation to say how John came by it. So they can't prove the 30-year that the Registration of Titles Act would require. But they can prove the 12 years that the Special Provisions Act will require. So what we do is that we refer those matters, instead of sending them to Titles Office under the Registration of Titles Act to a referee, we refer these matters to an adjudication committee. And this committee is a quasi-judicial body that deliberates on the rights and interests in relation to a specified land. So let me tell you a little about this committee, the adjudication committee. Next slide. Next slide, please. Okay. So the composition. An adjudication committee is composed of an attorney at law who has at least 10 years experience in civil law, a commissioned land surveyor who has at least 10 years experience in surveying, and I'll tell you why these are important, a nominee of the minister responsible for land, a justice of the peace. So you guys are very important to this committee composition. And usually it's a justice of the peace who resides in the community in which the land is situated or in a neighboring community, and such person from the community as is selected. Now, when the committee meets, say John comes to the committee and he says, I have been living on this land for 15 years, and everybody knows that I am the owner. He brings two persons from in the community to say, yes, the land was owned by John's father. When John's father died in the 70s, John started to live there, and he has been the person who has been in possession. But then the JP in the area, because she lives in the area, she knows John. And even if John doesn't know that she knows John's father. And so the justice of the peace says to the attorney, who is the chairperson, listen, John is not the only child, you know. John has a sibling who is Janet. And Janet just happens to live in the US. So at that point, the chairperson will ask John, where is Janet? Why didn't you tell us about Janet? And John will say, well, Janet is not interested. Janet is not coming back to Jamaica. At that point, we're going to have to defer the matter, ask that John get his attorney, or if it's referred through us, we will have to reach out to John's sister, Janet, to ask her to prepare a document for her to send that to say she has no interest in it. If when we call her, she says, oh, this boy is so wicked. I'm the one who's sending all the money to pay for the taxes. Every month, every year, I send on the money to him. And I see that he's paying it in his name, but, you know, he's my brother, and I don't think he's doing it for both of us. That's the point when we realize that there are two persons whose name ought to be on the title. And so the chairperson can't issue a record for John alone. The record will have to say that the land is owned by John and Janice. Okay? So we rely a lot on our justice of the peace, and we are going to be reaching out to a lot of you because we have some committees that are to be established, and we will need justices of justices of the peace to be a part of these committees. So when we call on you, don't say no. Okay. Next slide, please. Now, the function of the adjudication committee, as I said before, they have to examine the documents that are presented, and then we have oral evidence. So it's very informal. They come before the chairperson. They are asked, how do you know the land? How old are you? How could you have known the land? What you know about the land? And usually we ask the older persons in the community to come and give evidence because they would know the history. And then the committee also considers the evidence of other persons who may appear either in support or against the claim. Next slide, please. All right, so If the committee, oh my God. Just a second. If the committee members are feel satisfied that the person who is applying has the best claim, that they have been in open, undisputed, and uninterrupted possession for at least 12 years, and there are no undisclosed claims or anyone else having an interest, then a certificate will be issued naming this person as the owner of the property. Next slide, please. Now, what is the role of the justice of the peace in our land application process? Now, a justice of the peace is a person of unquestionable integrity who seeks to promote and protect the rights of individuals. In addition to upholding the rights of citizens, the JP is required to serve the public in attesting and authenticating documents under the official seal. For all of the applications mentioned herein, the applicant would be required to execute the documents in the presence of a JP if the person is in Jamaica, or a notary if they are overseas. Next slide, please. So what are the documents that will come to you? You'll find that if a person is making an application for first registration, they are going to come with a registration document. That document has to be signed in the presence of a justice of the peace because it's a declaration. Also, there's an additional declaration by the applicant that also needs to be signed before a justice of the peace. And the persons who are supporting the declaration, they also have to sign before a justice of the peace. If the survey is old and you're getting a surveyor's declaration, the surveyor needs to sign in the presence of a justice of the peace. If they want to add somebody to the title with them, the person who is being added has to give consent to be added on the title, and their consent needs to be signed before a justice of the peace. If we're doing an application for administration, whether by probate or administration, the oath needs to be signed in the presence of a justice of the peace. The supporting affidavits need to be signed in the presence of a JP. If they're giving a gift, or they're doing authorization letters, or they need to certify any document, it is the JP who has to do the witnessing. We rely on them to do it. Okay? Next slide. So one of the common errors, some of the common errors that we find, so we have an applicant submitting an authorization letter, but the authorization letter is written as if it's coming from the JP. So the authorization letter really ought to say, I, Georgette, hereby authorize the National Land Agency or LAMD to give my title to my cousin, John. I would have to sign and the JP will witness my signature. But the authorization is not coming from the JP, it's coming from me. The JP is witnessing my signature. Okay? Next slide, please. Another common error we find is incomplete jurat. So at the end where you sign in the presence of, there's usually a part that says the date when it's signed, the address that is signed, those things are usually missing. If those are not filled in with a document for court or a document for titles office, they're going to reject our document because of an incomplete jurat. So we ask as far as possible that you complete the jurats so that the documents are complete. So sometimes, again, we see documents which are signed and witnessed by the JP, but the seal is missing. And titles office is going to reject it for a seal because that's what they use to authenticate the JP. Also, the JP witnesses the document without an applicant's signature. So we've seen a lot of that. The document comes back in, we see the JP sign where the JP must sign, but the applicant did not sign. That is serious because no JP ought to sign a document, any blank document for anyone. The person ought to be before you signing because you're really witnessing their signature. So they need to be there. So that saves a lot. If I see a document comes back with the JP signature, but the person did not sign, it means somebody carried the document and give to the JP stamp it, but the person didn't sign. And I'll tell you how important it is that you don't do that. We see where the JP's name is not clearly identified, or sometimes in documents we see JP being listed as an occupation. It is not really an occupation. It is to be used when you're witnessing a document, but what exactly is your occupation? All right, next slide, please. We also ask that when you are witnessing, when you are marking a will, so when we are doing an application to the court for a grant, we are required to mark the will. That is, we take the original will and at the back of it, we put in a clause to say that I, John, hereby declare that this is a true copy of the will that I had signed to in 1999, for example. We ask that you do not date it because it's an original document and usually it is in support of the oath. So if you put a date before the date of the oath, then the registrar is going to reject our document because it's supposed to support it. So the date need to come after it. So usually we put in, well, when it comes from my office, I'm doing the legal work, I usually put in pencil, do not date. And that is why we ask that you don't date the marking of the will. Also, if you are acting as a witness to a will, our law requires that you have two witnesses, and it can be just two adults can be a witness. So you don't have to be a JP to witness a will. But if you are one of the witnesses, you don't need to put your seal on the will. All right. And we advise as far as possible that you don't give legal advice. You refrain from giving legal advice. And I tell you, if you are doing as I found when I used to be in private practice, clients bring documents where JPs prepare sale agreements, JPs prepare lease agreements, and they're not properly done. They don't take into consideration what happens if the sale falls through. They don't take into consideration some critical things that are necessary to make a document legal. And so when something goes wrong and that client now needs to use that document in court, we are unable to use it. So, you know, send them, I know they come and they sometimes don't have the money, but without expertise, I would advise that you send them to an attorney so they can get proper legal advice. Next slide, please. Okay, so we want you, what do we want at LAMP? Why are we speaking to you this evening? We want you to help us to share with your friends, your neighbors, the people in your community, the benefit of bringing their matters under the Special Provisions Act. You have all listened and heard the benefits. I expect to be hearing from some of you, but I'm sure you'll be sharing it with those citizens because I'm sure persons come to you and say, I want to add my daughter, but I can't afford the transfer tax. Send them to LAMP because they can get a waiver of transfer tax. You might have persons who come and say, boy, daddy died many years ago, but the will was not probated. We can't afford to probate the will. Send them to LAMP because we will help them to probate the will at a reduced price. We need your help to witness signatures on applications and supporting declarations. And we also need your help to read the documents to the persons when they come to you sometimes, because some persons are illiterate and they are signing to a document without understanding what they are agreeing to. So assist them with that. Refer persons to the relevant agency. I realize you guys have a lot of sensitization programs, which is to allow you to be able to know where to send persons to when they need help. Refer them to those agencies when they require expertise or legal advice that are not within your remit. Also, I want you to understand that when I see a document come into my department and it's signed by a justice of the peace, I get a sense of security. I don't have to worry if any fraud is happening. I don't have to worry if this is really somebody's signature. So we rely on you, we trust you, and we trust that you will do what is right so that we will have a reduction in fraud. Now, when we do an application, for example, for an adverse possession, this is an application where someone is taking somebody else's land and you have two persons who come and say, yes, we know the person. This person has been on land for over 12 years. A new title is issued in this person's name and the right owner comes and contests this in court. And if they do, all the persons who signed to the application are going to be called in. So if the supporting declarant, for example, is called in and the supporting declarant says, I never signed this document. then you are going to be called in to say, yes, the person came before me and I witnessed the document. But if somebody came to your home or to your shop or to your business place and handed you a document that was already signed and say to you, can you witness this for me? And you didn't verify that this is the person, you could very well be facilitating a fraud, right? You are really the middle person between us and the clients. They trust you, they know you, you know them. And so we ask that you help us to help them. Together, we want to help every Jamaican to have their lands titled and every Jamaican to be able to utilize their titles efficiently. Thank you so much.
Thank you, Miss Georgette. Excellent presentation. Lot of practical, important information shared just now. In the chat, we're seeing where persons want to have access to the presentation. I've indicated to them that we will try and facilitate that through the customs. We'll circulate with your permission.
Sure.
We would have gotten a number of questions and we're hoping to address those questions. And I have taken the liberty, Miss Georgette, I hope you will agree with me, to have a follow-up where you make the same presentation, because there are quite a few JPs who did not get to join us. And so they want to hear this information because land matters. So I'm hoping that you will be available in the coming weeks once more to make this presentation for those who would have missed it, and for those who did not quite get all the details, then they will be able to hear it once more and it will resonate with them. So
Sure.
in the chat, I'm going to give you, before we address the ones who will use the raise hand feature, I'm going to tell you about the first 6 questions that were posed. I'm going to start with the easiest one. Colleen Wise, she says, how can attorneys get this training from LAMD? So you will let us know how you can target attorneys to train them in relation to this. Mary Clark asked, at the beginning of your presentation, she had asked a question, how were the areas selected for these special provisions? I hope you would have recalled the first part of your presentation, where you'd have identified certain communities. Right, so she's asking, how were these areas selected for these special provisions? Then you had Donnell Howell, and he asked a question, what about persons who squat on a property who wish to get it legally? I know you'd have addressed this aspect, so it bears repeating. Then Carrion Barrett, she asks this question. She says, there are some scheme houses that were sold more than 10 years ago through NHT, but the titles are not available. Is it possible for persons to come and access that title through NLA, or do they have to go back to NHT? That's for scheme houses that were sold more than 10 years ago. Mr. Z. Francis, he asked, what if the plan is older than 7 years? Because you'd have emphasized that the plan must be 7 years. He says, what if the plan is older than 7 years, but the surveyor died? What can we do? And then Melrose Hennings, she asked, what about lands that is sold without a title? What can be done in relation to that? So while I allow you to look at these questions and then answer, I'll be checking the listing for the raise hand. So you can go ahead and address
Okay,
those.
so the first question I heard was, how can the attorneys reach out to us? So basically on the NLA website, whenever we are having a seminar, it's usually announced on the website, but if you are proactive, you can send an email to myself or any member of the LAMP to just indicate that you're interested in being a part of the seminar. So we have the seminar once per quarter. And in fact, since this year, we've been having two. We have had two every quarter because the demand has been so great. And we can only do a quorum of about 45 at each time because it's a working class and we want to ensure that people understand what is happening. So the attorney just needs to write to us, tell us that they are interested. Our business services division will reach out to you to tell you what the cost is and to tell you how to register. Okay? The second question is how, and I'll send you my email so you can share. How are areas selected for project areas? So initially, the first area was St. Catherine, and it was a project because they wanted to see how well they could just focus using all the resources on getting titles. So it was first a project, and then what they did was to look at the parishes with the highest level of non-registration, and we found that St. Thomas, Portland, St. Mary, and St. Catherine had the highest level. And so we were focusing on those parishes first. And it also had to do with just availability of funds. So we had to do it as the need arose over time, and based on recommendations that we would have received, you know. But as was indicated, all parishes have now been declared, save and except for parts of Kingston and St. Andrew. So the third question is, how can a person who's squatting on a property legalize that? So it depends. So if you're squatting on land that belongs to a private person, that land has to be a registered land for you to be able to take it over. So if you are living on the land, you bill on it, or you have a farm on it, you fenced it, you are treating it as if it belongs to you, you have receipts and so on to show that, you know, you are taking care of this property. And as a matter of fact, everybody in the area just thinks it's your land because they've always seen you there and they're willing to attest to that. Then you can do an application to the registrar of titles, which is called an adverse possession application, to have the lands moved out of the original owner's name into your name. However, if the land that you're squatting on belongs to the government, the Commission of Lands, unfortunately, you have to be on that land for at least 60 years before you can claim that. And that is usually very difficult. And it's not impossible, but usually very difficult for someone to show 60 undisturbed years. Because if you are living somewhere for 12 years, for example, but during that process, the person took you to court or served you with a notice, then the possession would have been disturbed. All right. And then you say that there are some schemes that were sold by the National Housing Trust, but titles are not available. Unfortunately, we cannot complete matters that are started by another ministry. The land would be in the National Housing Trust, and so they would have to complete those matters and make titles available. All right. So you ask if the plan is older than 7 years, but the surveyor's died, you can ask another surveyor. Another surveyor, he will charge you to check the boundaries, but he can speak because what the declaration does is to say that the boundaries have not changed. So another surveyor can do the declaration. And I think the sixth question was, what happens where land is sold without titles, right? Okay. So if a land is sold to you without title, then usually it means that ultimately what you're trying to do is to get a registered title for it, right? But you would need to show how you came by it. So if you bought it, you would have gotten a conveyance or some kind of agreement from the person who sold it to you. But if you check the tax, if you get a survey done and you check the tax receipt, you may find that the person who sold to you, for example, if John sold it to you, you might look on the tax and find out that it belongs to Georgette on the tax roll. So if you are able to trace that and get somebody in the area who can speak to the fact that they knew the land had belonged to Georgette in 1970, and then Georgette sold it to John, and then John sold it to you. Once you can trace that 30-year period, you can apply for title. if you're having difficulty tracing that 30-year period, but you can trace the 12-year period, then we can refer the matter for you to an adjudication committee. As I indicated, the committee will look to see that you have been in possession for 12 years. They will issue a certificate, and you can use that certificate along with your plan to apply for a title.
Thank you
I think
very
I answered the questions.
Ms.
Yes.
Georgette. You have answered it ably. There are a few more in the chat, but I'm going to address the persons who would have raised their hand to hear from them. So we want to start with Baldwin Leslie.
Thank you, ma'am.
Lee.
Let me just
Yes.
try to unmute myself.
We're hearing you. We heard you clearly. Go again, Mr. Leslie. We heard you clearly before. So just unmute your mic and go again. Okay, while we wait on Mr. Leslie, I'm going to ask Eugenie Lewis to just go ahead and unmute mic and ask your question, please.
Thank you very, very much, Miss Manpreet. Good evening, everyone. Yes, I'm checking on this. Sorry, I have this question. If an owner dies, but the owner left a will, the will was not probated, but one of the executors of the will is also a beneficiary of the will, and that executor dies. The other executor is not interested in having the will probated. What can the beneficiaries do, especially the beneficiaries of the beneficiaries of the executor that has died? What can they do to have their portion of land from the previous executor? Two executors, one has died, one is not interested in probating the will, and the one that died also left a will that his portion could go to his beneficiaries. What can those beneficiaries do?
So the one who died, his beneficiaries can actually probate his will, and that executor for the person who died can step in the shoe of the one who died and probate the will of the first will.
So
Okay.
the executor that is alive is not interested at all in any probation.
Right. So you can ask him to renounce, ask for him to just do a renunciation. So you probably need to get an attorney, but the attorney would do a renunciation so he can say, I'm not interested. They would register that. And then the other executor would be left. So now that he's dead, his executor can probate. Once that probate is done, they step into the shoe of the other person. The alternative to that is that the beneficiaries can actually apply. Remember, I told you can do what is called a grant of administration with will annexed.
Oh.
The beneficiaries can determine, join together the primary beneficiary, and they can apply using a letter of administration with will annexed, using the will to say that one executor has died and the other one refuses to act, and so they are applying.
Okay, thank you very much. Thank you very much. We have to get a couple more persons.
Okay, then. Thank you. Thank you.
Thank you very much. Leslie Gray D'Souza, if you're able to unmute your mic.
Good evening. I need to find out if the land has grave on it. It's unregistered. If grave land can be sold.
Yes, if you find somebody who is willing to buy it.
Okay. So how it's also unregistered. So what do what does the purchaser do to do they say the seller needs to get
Miss
it
Leslie
registered
Gray,
before?
could you hold your question? Miss Leslie, Sharon Michael, We're hearing you. Please mute your mic. Miss Leslie Gray, complete what you're asking.
Does the seller has to get the title first before the sale agreement goes through?
It is usually advisable to buy land that has a title, especially if you're trying to get a loan to buy it or you want to utilize it later on. But you can buy land that's unregistered. We don't encourage it at all, though. Usually the person who has the unregistered land has a better chance of getting a title because they would have a greater history. They can prove a longer time of being in possession than you. So they could actually apply, they could do a sale agreement with you and they could do an application and nominate you to be the person whose name is supposed to go on title. So that can work also. Right.
Okay, thank you very much for that question and the answer. Merlin Senior. Merlin Senior, are you able to unmute your mic and pose your question?
Can I come back in now, Mrs. Swigan?
Okay, let me hear from you, Mr. Leslie.
Thank
Merlin
you.
Senior.
Thank you very much. Just quickly, earlier on, Mrs. Tyson had mentioned that if you want to cut off a bit of land from a larger piece, about it to be treated as a subdivision. I think I heard that. Whose cost would it be? Is it the vendor or the person who wants to buy?
That is something that the vendors and the purchasers have to decide with, between themselves, but usually it is the vendor's responsibility to issue a title when they sell. And you can't get title without a subdivision approval.
Okay.
Okay, thank you very much for that question, and Ms. Georgette for answering. Merlin Senior, are you able to unmute your mic? If not, I'll move on to someone. You're able to? Go ahead. Oh, you're married. You're Senior Hawthorne.
I'm just listening. Yes, ma'am. And I just got in, just listening to what's happening. So later on.
Okay, then. Patricia Salmon, can you unmute and
Yes,
go
I
ahead?
can. Thank you so much. Good evening, everyone. I'd just like to ask Mrs. Harrison, what's an alternate to grant probate document, and how would I go about getting that done?
Not sure I understand the question.
Okay, so I have a cousin who is trying to get the title for her.
Could you hold a minute, Miss Patricia? We're hearing from Marvet Webb. Marvet Webb, we're hearing you. Please mute your mic. Okay, go ahead, Miss Patricia.
Yes, I'm trying to assist a cousin whose father would have died and did not get a title for his land. She's the only child, and when she tried to get the title, someone told her she was advised to get an alternate to grant probate document. She would have to take that along with the death certificate and other documents.
Okay,
but
so
I don't know what that is.
Not make a will?
He did not make a will.
Okay,
no.
So she would need to get a letter of administration.
Oh, sorry, not that he did not make a will and he did not get a title, but there's a sale agreement.
That's fine.
Yes.
So if he didn't make a will, but we can show that he's the owner because she's able to establish that he was on it 30 years before he died, the matter can be brought to us at the Land Administration Management Division. My legal team will help her to apply for a letter of administration that will put her in the shoe of her dad, and then in her capacity as administrator, she can apply for a title.
Thank you.
Okay.
Okay, so we're going to take it now 7:02, and I promised to end the session by within 1 hour and 30 minutes. So I'm going to take two more persons. Colleen Josephs, if you're able to unmute your mic, please go ahead.
Good evening, everyone.
Good evening.
Okay, I am trying to assist elderly lady in my community. Her husband died, and she had submitted the document, she said, to LAMP from 2011, and she submitted all the required documents, paid the required fees, and until now she haven't heard anything. She did a letter and signed it and asked me to witness it, but I don't know, who do I email this letter?
Email it to me. Can I just give the email address right now?
Yes, you
Sure.
may go ahead.
Okay, so it's georgette.stewartharrising@nla.gov.jm.
At nla.gov.
nla.gov.jm.
.jm.
So everywhere where you see the beginning of my name, make it cap. So capital G, capital S, capital H. You got that?
Okay. Yes, I got it.
Georgette.stewartharrising@nla.gov.jm.
Really appreciate it. Thank you so
Please
much.
ensure you give me the full name of the person, because that's how I'll be able to check for that file. 2011 is long, long, long time ago. So.
Yes, and you know, she's worried that maybe she will die soon, and her daughter, you know, will not get any benefit.
Send it as soon as possible to me, please.
Okay,
so
we'll
I can check.
Thanks a lot.
Okay.
Your last name,
No problem.
Georgette, can you please repeat the email? Thank you.
It's there's somewhere I can put it in the chat.
Yes, I'm typing it in the chat. I'm typing it. You can go ahead and repeat. I'm typing in the chat.
Okay, so it's georgette.stewartharrising@nla.gov.jm.
It is posted in the chat, so
that's
everyone
correct.
should see.
Okay.
So we're on to our last raised hand. This is Miss Corinne Davis. Miss Davis, please unmute and go ahead.
Good night, everyone. Mrs. Stewart Harrison, thank you so much. Very informative session. I have my brother passed, my sister passed. I'm in possession of the registered title. My sister, two children, that's 18 and 8, they're living with me. How do I get them to be on the title?
Okay, so that's a long question, because it seems to me that that property belongs to all three of you.
The property belonged to it's a property that was subdivided, so we all have different parcels. But my sister passed. Yes, my sister passed, and our two kids are here with me. My brother passed.
They're under 18.
One is 18 and one is 8.
Okay, so the matters where they're under 18, those matters have to be referred to the Administrator General's Department. Because there are minors involved. There is a minor involved, so that the administrator can do an application for their moms in their mom's estate, and then in their capacity as administrator, do an application for registered title for them.
Okay. And for the 18-year-old?
It will still apply because they're both related to the same. So even though one is an adult, the fact that there is a child, the application has to be done by the Administrator General.
All right, thank you. Thank you so much.
Sure.
Okay, so I would like to thank all our JPs who stayed with us. Yes.
I saw a question in the group that I wanted to just address. I think it's
in
important.
The chat.
In the chat, right?
Well,
so someone had asked if Geoland.
Just before you get to, there were a couple questions in the chat. The key one, I think, is that they're asking, is a LAMD at local parish council? So where are you situated? So you'd like to share where the Land Administration and Management Division is situated across the island?
Okay, so we are located at 8 Arden Road. That's where our office is. Right. And we presently because just recently, since we no longer have a contract with Geoland, and that's the question the person asked, if Geoland is the same as LAMP. Geoland was a contractor to LAMP. So what happened was that we had jurisdiction for 4 parishes: St. Catherine, St. Thomas, St. Mary, and Portland. And Geoland did work for us in all the other parishes, from Clarendon back to St. Anne. But because we no longer have that contract with Geoland, then it means that all matters have to come to us at 8 Arden Road. So we now have the entire island. All right, so if you go to Geoland, you'll be going, it's as if you're going to a private attorney who is certified by us, and that's fine. But they're not LAMP.
Okay, thank you very much.
Okay.
Let me see if I can read out a few of the questions in the chat, but we do need to wrap up. Here, they're asking, do you have the names of the lawyers who work with your department, especially in Trelawney? That's one. So they want to know the names of lawyers who work with your department who are situated in Trelawney.
All our lawyers are at 8 Arden Road, remember?
So everyone is situated at Arden Road.
Yes.
How do I go about having my husband's name added to my title?
Okay, so that is a transfer. So we basically just need information. We have a form that they would come in and speak to our customer service officer. They would have them fill out the form, bring a copy of your title, copy of your marriage certificate to show that he's your husband. And we will open a file. We'll contact you by sending you an invoice and sending the documents to you for signing. When the documents are signed, then we do the waiver of transfer tax and we do the application on your behalf to have his name added.
Okay, thank you for that. This person is asking, what about land that have been used for several years but is a commercial area? Can we get a title for that?
You mean, can they adversely possess it? Is that the question? Is it it's a commercial area, but it belongs to someone else? Yes, if you have possessed it for 12 years.
I don't know if I can talk because that question is for me.
Yes, you can go ahead, Ms. Rudeco, but please make it quick.
Okay, all right. So my family works on Ocean Beach and have done so for several years. So I had initially asked an attorney if we'd be able to just officially get a title for it, but the attorney did her search and said that it's a commercial area.
Is it a commercial area or it's owned by the Commission of Lands?
I'm not, because it was some time ago, I'm not sure. I think I remember her using the term commercial area, but I don't know if probably.
I'm not sure, because if it's owned by the Commission of Lands, then you know that it's going to be very hard for you to prove that 60 year. But if it's a commercial land owned by a private owner, so when you do your checks, it's owned by a private owner and you have been on the land for over 12 years, undisturbed and without any interruption, you can actually do an application for adverse possession.
Okay, is it, can I contact you if I want to follow up?
Yes, Ms. Rudico Simmons, you can. Her email contact is in the chat. Also, Mr. Linton, where he says, Georgette, can you come and present at my school, Old Harbor High School? So Mr. Linton knows that he's to send you an email, and
Mr. Linton knows how to contact me.
Very good. There are a couple more questions that I was trying to get to. Is there a guarantee that my application under the special provision will be approved? Does the minister have a quota that he approves per year, etc.? Or is this as long as I apply, it will be approved?
Okay, depends on what the application is. So if it's an app, the minister only approves applications for waivers. And as long as you meet the requirement of the 7-year informal possession, he approves everything. He's not going to be checking and doesn't have a quota. So the other matters are based on your, whether you qualify or not. So we would, if you bring the matter to us, we would have to review your information to determine what's the best way to send it. So we may say to you, you don't have enough years, just go and chill for another 3 years and come back to us in 3 years' time. You know, continue to live on the land because you haven't shown the 12-year period, for example. You don't have enough time. But if you do qualify, then we will guide you as to the quickest and the best route to take.
Very good. What do you do if you have been paying the taxes and persons are squatting? You now want to sell the land. What do you do?
So the land belongs to you and you have persons squatting on it. You will need a lawyer to give them notice. So you have to take them to court to get them off.
Okay, thank you for that.
And hopefully they haven't been squatting for a very long time without you interrupting, because they could have a good claim of possession.
Possession.
Yes.
Okay, what is the turnaround time for first registration?
I can't give a time for that, but I'd say reasonably, if all things are in place, you should be able to get a title between 4 months and a year.
Okay. Okay, I think I'm going to end it there. I would like to thank everyone for their participation. I would like to thank you very much, Ms. Georgette, for making such an excellent, informative, and practical presentation. We're hoping to get you back so we can have this presentation, and any questions that we did not get to in the chat, we'll be able to treat with it then. In the interim, though, with your permission, we will have the presentation circulated through the custodians to the JPs.
That's fine.
Justices of the Peace, over 800 JPs joined us. Thank you very much for joining us. Thank you for staying with us. We look forward always to your interest and engagement, and we at the Ministry of Justice and Constitution Affairs, getting used to the new name. We are very happy to have you. We're very excited when you receive our invitation, albeit late notice. We are reminding you that we're hoping to organize another sensitization session that's for next week or the week after with the Minister of Justice and the Minister of National Security, where we'll be discussing peace across Jamaica. That will be an excellent session and the role that you can play. And then with Georgette's support, we will have another session with her. So thank you once again. And just to say to you that those persons, I did take your names down from the parishes of St. James, Clarendon, St. Catherine, St. Mary, who indicated that they have not gotten their new seals as yet. We have seals in our possession, so we will reach out to your custodians and we will make an arrangement to come into your parish so we can do the recall and replacement for you. For Kingston and St. Andrew, quite a few persons for Kingston indicated that they're not with their seal. Just a reminder that we have now commenced the recall and replacement for Kingston. We're in the process of doing that, meaning that I'm saying we're purchasing the seals. We haven't gotten it as yet. As soon as we're in possession of the seals for Kingston and St. Andrew, we'll notify your custodians, and then we will reach out to you so that you can bring in your old design seal and we will replace it with a new design seal. Ladies and gentlemen, Justices of the Peace, thank you very much for your engaging participation. Thank you very much for your patience with us, especially at the beginning of the session. We want to once more thank Ms. Georgette for her excellent presentation. We thank you for the questions posed, all excellent questions. And so we look forward to being with you for another session in the coming weeks. Have a good night. I am Julia Moncrief-Wigan from the Ministry of Justice. Take care.
Thank you and good night.
Good night.
Bye-bye.
Excellent presentation.
Have a
Good night,
blessed
Good
everybody.
night, all. Good
Night,
night.
everyone.
Thank you, Miss Georgette. Good
Good
night.
night,
Thank you
everyone.
very
Thank
much.
you.
Excellent.
Excellent. Thank you, Miss George.
Good night, everyone. Thank you very much.
Good night.
That was a
Good night, everyone.
Presentation, good night.
Thank you. Thank
Good
you.
night. Great presentation. I will listen again tomorrow. Good night.
Great presentation.
Thank you, Ms. Georgia. Thank you very much. Presentation.